Well, I think we're now ready to resume our hearing. Ms. Rose.
Yes. So, my lords, my lady, we'd finished going through the written terms, and I just want to say a few words about the regulatory context in which the contracts operated. And you have the two relevant statutory materials in the bundle starting at page 707. At 707, you've got an extract from the Private Hire Vehicles London Act, 1998. And you see at section 2 that nobody is allowed to accept private hire bookings unless they have a private hire vehicle operator's license. That's the license that ULL has. Then at section 4, you see the obligations of London operators, which include that any vehicle provided by him for carrying out a private hire booking is a vehicle for which a London PHV license is in force, driven by a person holding a London PHV driver's license. So you have a separate licensing requirement for the operator who accepts the bookings and each individual driver who drives the cars. And there is nothing in this statutory regime that requires that the drivers are employed by the operator or are workers providing services to the operator. The requirement is simply that it's the operator who makes the bookings. And as we shall see, in this industry, it's always been the case, certainly for as many years as we've been able to trace it, that there has been a mixture of models under which there are self-employed minicab drivers who contract directly with their passengers through the agency of an operator. And there are also fleets of cars where services are provided to the operator and the operator contracts with the passengers. And then at subsection 3 here, you see a summary of requirements that apply to the PHV operator. And if you turn over then to page 710, this is the PHV London Operators Licenses Regulations 2000. And you have a number of particular conditions for licenses that are set out here. And you can see that they include Regulation 9.3. If a person is required to do so by a person making a private hire booking, agreeing the fare or providing an estimate, so the operator has to do that. Then at over the page at sub-regulation 7, there has to be a procedure for complaints and for lost property. Then at regulation 11, particulars of the booking. At 12, particulars of the vehicle, particulars of the driver at 13, records of complaints at 14, records of lost property at 15. So there's detailed prescription about the types of records that have to be kept and procedures that have to be in place, including complaint and processes for agreeing fares, all to be operated by the private hire vehicle operator. So now I want to turn to the way that the relationships operated in practice, the reality of the relationships. My overarching submission here is that it doesn't matter what approach you take to auto-cleanse. Whether you take the approach that in my submission is legally correct, or you take the approach that the Court of Appeal adopted, or you take the even more broad approach which is being advocated for by the respondents in before this court. Whatever approach you take to auto-cleanse in my submission, the reality of this relationship accords with what's recorded in the written contracts that we've just seen. And the findings in relation to the reality of the relationship are set out in the Employment Tribunal judgment, and that's section starting at page 367.
Can I just ask you before we
Yes,
go to it? I'm just looking again at Section 2 of the Private Hire Vehicles Act on
Yes.
MS
Yes, my lord.
707. In looking at that, the implication of that is that the driver who doesn't have a license
Yes,
can't accept a booking.
that's right, my lord. That's right.
And he can't do that. And equally, he couldn't do that through an agent.
Well, no, my lord, that's not right.
Oh.
He can do it through an agent, but he can't do it himself. The operator has to.
So you say that if the driver employs an agent to accept private hire bookings,
Yes.
then the person accepting the bookings is not the driver, it's the agent.
Yes, for the purpose of this statutory regime, yes. But the contract, that the booking is accepted by the operator, but the contract for the supply of driving services is entered into between the driver and passenger. And that's a standard model in the industry, as we're going to see in a minute.
Okay, right, thank you.
And indeed, as your lordship rightly points out, it's the only way that private hire drivers can operate as self-employed businesses, because drivers are not allowed to apply for hire, only black cabs can apply for hire, and they're not allowed to accept bookings themselves. That has to be done by an operator operating from premises. The only way you can work as a self-employed minicab is through an operator, through a minicab operator. Now, turning to the way that the relationships operated in practice, the Employment Tribunal judgment, and we start at paragraph 13 at page 132. And this section, it's basically paragraphs 13 to 27 and 39 to 57 of the Employment Tribunal's judgment. My submission is that none of the findings of fact in these paragraphs are inconsistent with the terms that we've just been looking at, the express written terms, or with the regulatory context that we've just looked at. In fact, in my submission, every obligation identified by the Employment Tribunal in these paragraphs is expressly included in the written contractual material that the Employment Tribunal then goes on to find to be fictional. That's a pretty remarkable state of affairs. There are some points, I don't have time to go through all of these paragraphs, but that's my overarching submission. There are some points that I want to emphasize. Paragraph 15, you can see that it's stated that passengers are not obliged to state their destination when booking, but generally do so. And you'll recall that that's consistent with what was said in the driver terms that we were looking at. The significance of that is that, as at the date we're considering, Uber London might not know the destination at the time the booking was accepted. And that's going to be significant when we look at the Court of Appeal's judgment. Then payment, you can see they start addressing that at paragraph 18. And the description of the payment system in that section is wholly consistent with what is said in the contract. Then paragraph 26 deals with issues where Uber rides are procured by fraud. And what they say in 26 is Uber's general practice is to accept the loss and not to seek to pass it on to the driver, at least where Uber's systems have failed. So what you see there is it's not found that Uber offers a general indemnity to drivers if a ride has been procured by fraud. It's their practice to reimburse if Uber's systems have failed. And that, again, in my submission, is exactly what you would expect. If the proprietor of the app has not properly protected its systems against abuse, you would expect it to pick up the tab. Cost of cleaning, paragraph 27, it said the respondents will in some circumstances pay drivers the cost of cleaning vehicles soiled by passengers. And then they say this: it was not suggested such payments were conditional on Uber receiving a corresponding sum from the passenger. Now, in my submission, again, there's nothing inconsistent with the relationship as described in the contract there. As the court has seen, Uber had the right under that contract to recover the cost from the passenger. Whether Uber chose to exercise that right or not is a matter for its commercial discretion. And obviously, it's going to depend on whether it thinks it's in its commercial interest to do so or not. Then recruitment is dealt with particularly at paragraph 41, paragraph 40, driver recruitment or onboarding. And the tribunal is very exercised by the question whether or not there is any interview of the drivers. But the finding that they make, this is at page 376, is that there is a very basic interview in which they check whether a driver can communicate adequately in English, and that drivers are required to present themselves and their documents personally. And they say, the tribunal, they're subjected to what amounts to an interview, albeit not a searching one. Now, again, in my submission, that's exactly what you'd expect under the terms of this agreement. Firstly, because the agreement itself expressly makes access to the app conditional on the driver meeting various requirements, including possession of all these documents. And secondly, because of the regulatory obligations on ULL to verify and to keep copies of the necessary documents. Then there's the fact at paragraph 43 that there is no obligation to use the app, and that's accepted. Then the driver supplies the vehicle, and the driver is responsible for all costs related to owning and running the vehicle. So none of that is in dispute. Then there's the heading Instruction, Management and Control or Preserving the Integrity of the Platform. And they refer here to a welcome pack that drivers receive. It says at paragraph 48, containing various tips and what Uber looks for. And what the court will see if you read through there is that what's set out here is exactly what's said in the contract and what you would expect in order to maintain the commercial integrity of the app. Then at 50, 49 and 50, prohibiting contact with a passenger and not exchanging contact details. Now, this is described by the tribunal again in a vacuum, as if these were elements that show that the contract's fictional. But as the court has seen, these are provisions that are expressly in the contract. Then we come on to the question of whether or not drivers are obliged to accept trips if they've got the app switched on. And at 51, the tribunal says, this is page 378 at the bottom, although a driver is nominally free to accept or decline trips as he chooses, the acceptance statistics are recorded, and an Uber document shown to us warns you should accept at least 80%. Now, this court will have seen from our written case that we don't accept that the tribunal here is making a finding that there's an obligation to accept 80%, and that if it had made that finding would not have been consistent with the evidence. But in our submission, it's the following paragraph that matters, because what the tribunal then says is drivers who decline 3 trips in a row are liable to be forcibly logged off the app by Uber for 10 minutes. And they derive this from an Uber document called Confirmation and Cancellation Rate Process, referring to the penalty box warning. So the finding that the tribunal makes here is you're not obliged to accept a trip, but if you decline 3 in a row, you can be penalised by being logged off for 10 minutes. Now, in my submission, that is not what the document that the tribunal is here referring to says. The document in question is at page 637 of your bundle. And you can see that's the document headed Confirmation and Cancellation Rate Process, which is the document the Employment Tribunal is referring to here. But what you see is, first of all, at 154, the point that if you're logged on, it's assumed that you're available and that otherwise it's very frustrating for users. That, again, you will recall, is expressly stated in the contract itself. Then over the page, solution, this is 638, identify partner drivers with very low confirmation rates or very high cancellation rates and send a notification message. And then at 3, if partner drivers continue to have very extreme metrics, tag their account so they're forced offline for 10 minutes if they miss 3 consecutive trip requests. And then you actually see the policy further down. And you'll see, first of all, this policy only initiates if a driver is accepting less than 45% of trip requests when they're logged on over a 7-day period, more than 35 dispatches. And the first thing is just to send a reminder as to why confirmation rates are important. Then if in a second 7-day period, they are confirming less than 30% of requests, they get a second email. And then in the third 7-day period, confirming less than 30% of requests, at that point, they may be automatically logged out for 10 minutes if they refuse 3 in a row. Now, in my submission, that is a very far cry from the tribunal's interpretation of this document at paragraph 52. And it is wholly inconsistent with there being any obligation on drivers to accept a trip if they're logged on. What it is consistent with is the express terms of the contract that we've seen that say you're not obliged to accept a trip if you're logged on, but if you're logged on, it's an indication that you're available. And if you repeatedly refuse to accept trips, we may log you off. And similarly, the same policy you'll see in the following pages of this applies in relation to cancellation. Again, it kicks in only after prolonged periods of very high cancellation rates. And in fact, what these materials show is that there is no contractual obligation to accept a trip. It's inconceivable if you had a situation where a person had agreed to provide their personal services to an employer and refused to do so in 70% of cases over a period of weeks, that their employer would tolerate that situation. Inconceivable. And what's the penalty? It's not requiring the person to work or to accept any trips. It's simply saying log off for a short period, because there is no ability at all to require the drivers to work. The only obligation on them is if they're not available to work, they should log off. It's simply the touch of a finger to a phone screen. And the policy we've just looked at specifically states, and the warning to the driver specifically reminds them, that remaining logged on when they're actually not available to accept trips is a breach of their services agreement. And as we've seen, it is a breach of the services agreement. So there's no sense in which this can be said to be an indicator that that agreement doesn't reflect reality or is fictional. This is simply an implementation of the services agreement. Coming back to the tribunal judgment, paragraph 53 in relation to cancellations, they make the point that it's a breach of the agreement unless there's a good reason for cancelling. They say there's no cancellation policy. As a matter of fact, drivers were offered a screen which gave them a range of reasons for cancelling, which can be taken to be at least examples of good reasons for cancellation. You will see that it's in the supplementary bundle that we handed up yesterday, and it's at page, well, I've got it, it's the last page in the bundle. I've got an electronic page number 2340, but it's the last page in that bundle. And that is a document that was before the employment tribunal. It's the screen that comes up if a driver is seeking to cancel. You'll see it includes other, as well as things like rider no-show, wrong address shown, fraudulent rider, and too much luggage. In relation to routes, sorry, in relation to the 80%, before I leave it, I don't have time to go through that in detail, but can I refer you to our written case where we deal with the 80% issue at paragraphs 121 to 123, and that's page 123. Routes are dealt with at paragraph 54.
Okay, I'm sorry to interrupt you for a moment.
Yes, my lord.
It's just in case anybody was having trouble finding it. That last document is on page 43 of our second bundle.
That's right, Lord. Thank you. Routes. The tribunal finds that no Uber manager instructs the driver to take any particular route. In practice, the app's mapping software determines the route for most purposes. It's clear from Mr. Farah's evidence that if an issue arises as to whether a passenger should receive a refund on the ground the driver didn't follow the most efficient route, ULL starts from the position that it's for the driver to justify any departure from the route indicated on the app. To which my response is, well, obviously, that's its position. Because if you have a situation where the fare is determined in part by the distance driven, and you have a recommended route, and where the passenger is complaining that the route was excessively lengthy, that is obviously going to be the logical starting point. That's hardly surprising. It doesn't follow that Uber is dictating the route. Then ratings at paragraph 55. This is referred to as a method by which Uber seeks to exert control over drivers. Again, you can see here, as very often in this section, that the tribunal doesn't differentiate between ULL and UBV. As we've seen, the ability to rate is a condition of access to the app, as are all of the provisions that we've been looking at here. They're all expressly set out in the agreement, and the tribunal simply doesn't acknowledge that. It treats them as if they were, in a vacuum, elements of a relationship between the driver and ULL. Actually, all that they are is terms of the express written agreement being operated in accordance with that agreement. Then there's reference to serious conduct being dealt with through a driver offence process. Well, we've seen, again, express provision for that in the contract and regulatory provision in relation to a complaints process. And then finally, ULL's practice of directing messages at drivers presented as recommendations, advice, tips and feedback, which the answer is, well, yes, that's exactly what you'd expect, since Uber is seeking to maximise the use of its app for its commercial purposes. Then, after they've dealt with the regulatory regime, at 61 to 66, they set out various factors that Uber relied on. Then at 67 down to 69, they identify some uses of language by Uber, which I'm going to come back to. So those are the findings of fact. And in my submission, there is absolutely nothing in those findings which is inconsistent with the written agreements we've looked at, or which would support any conclusion by any test that the written agreements didn't reflect the commercial reality. If you ask how in substance, I mean, you can quibble about wording and use of language like customer instead of driver, but in substance, how would you expect the written agreements to be different if Uber's characterization of this relationship is correct? Pretty difficult to answer. The written agreements describe what happens. So our first submission on that basis is that there is no inconsistency between the substance of the rights and obligations owed under the written agreement by the driver to UBV and the way that the relationships operate in practice. There is no equivalent to the position as it was in AutoCleanse, where you had a written agreement that says you can send a substitute and a finding that in reality you could not. Our second submission is that once you accept that those are the rights and obligations, those that are first of all in the agreement and secondly enumerated in the findings of fact that we've just looked at, that there is nothing about those rights and obligations that is incompatible or inconsistent with a relationship in which the drivers contract directly with passengers through the agency of ULL. And the suggestion is that, particularly because of the degree of economic dependence of the drivers on ULL, or the degree of control that ULL exercises, that in some way means that this cannot, in truth, be a relationship of agency. That's the proposition. And my lords, in my submission, that is contrary to high authority in at least three different contexts. First of all, in the context of this particular industry, in the context of the private hire vehicle industry, there are many examples of relationships of exactly this character between drivers and private hire operators, which have been upheld as genuine, both in the context of employment status and in the context of tax. But in the specific context of protective public interest regimes, statutory regime. The second context is that in different industries, in different factual contexts, it has similar relationships with a similar or indeed greater degree of integration and economic dependency have been held genuinely to be agencies and not worker contracts or employment contracts. And there are two cases in particular, the Hong Kong case and the Quashie against Stringfellows case, in both of which, in my submission, the individuals were more integrated into the business of their agent, more economically dependent, but in both cases were held to have been providing their services to customers through the agency of the person at whose premises they work. Yes, my lord.
I think I'm right in saying that there's no written contract in this case between ULL and the passengers.
That's correct.
So how do you say that the agency agreement was constituted between ULL and, sorry, I say the passengers, I meant the drivers. There is with the passengers. But you say that ULL were acting as the agent of the drivers. Was that created by contract? If so, how did the contract come into being? Or if not, how did the agency get established?
My Lord, of course, there is no requirement for a contract in order to establish an agency. What's necessary is consent or authorization.
On both sides.
And you see that expressly in the terms that we looked at, the terms between the driver and UBV. The driver expressly acknowledges that the contracts will be entered into through the agency of the local affiliate.
Yeah, but UBV isn't the principal, isn't the agent. It's no good to a third party. The question is, how have you agreed with the agent that they're going to be your agent?
My Lord, in my submission, you don't have to agree with the agent they'll be their agent. You have to consent to them doing it. The agent in this case is a wholly owned subsidiary of UBV, expressly referred to in the contract with UBV as having particular rights and functions, including this function, and that's the basis on which the parties conduct their relations. And in my submission, there is nothing at all unusual or surprising about that.
Surely there has to be communication. Sorry, I didn't mean to interrupt, my lord.
Sorry. Sorry, Melanie.
No, I hope I didn't interrupt. Surely there has got to be communication, even on the basis that it's a relationship that arises from consent expressed in the
Yes.
There's still got to be a communication between the putative agent and the putative principal at some point. I think my lord was really asking that, if I may.
Yes.
But my lady, of course, you see that. What we've just looked at is that the driver attends at the offices of ULL in person with their documents and offers their documents to ULL for them to retain for this purpose. So if you're looking for an express appointment of ULL as agent, it's right there in the onboarding or interview process.
Thank you.
And so my submission is that this is a relationship of agency is consistent, first with practice in the private hire vehicle industry, secondly with findings that courts have made in other industries where there's a high degree of integration and control and economic dependency, and thirdly, it's consistent with decision of this court in the context of an internet intermediary as an agent, and that's secret hotels too. And in that case, you see this court upholding as agency a situation where the agent had all of the bargaining power, where the terms were highly unequal and in favor of the agent vis-a-vis the principal, and a high degree of control was being exercised by the agent over the principal. And for that reason, the courts below had said this isn't a genuine agency. In reality, the internet intermediary is transacting as a principal, and the Supreme Court said, no, that's not right. The parties have characterized it as agency, and it is agency. And the inequality of bargaining power may explain why the terms are very favorable to the agent, but it doesn't lead to the conclusion that the terms are a sham. So there's no inconsistency between this type of relationship and the establishment of agency and then a direct contract with the passenger. So can I just make those submissions good? And the first relates to this particular industry. And I want to show the court the decision in Mingley and Pennock. That's at page 919. And this is a case of a traditional minicab company. My submission, ultimately, if you ask what's the difference between Uber and a traditional minicab company, the difference is one of scale. That a minicab company may have 30 or 100 or 1,500 cars on its books. But Uber, because of its innovative software, can have many more drivers on its books and can much, much more efficiently connect them with their passengers for the reasons that I've already explained. But ultimately, when you look at the functions and you look at the relationships, they're not different in nature, they're only different in scale. So the issue in Mingley is pretty much the same as the issue in our case. The Court of Appeal here said, oh, it's different because the question was whether the minicab driver was an employee. But it wasn't employee in the sense of contract of employment, it was employee in the sense of discrimination law. And I've shown you, Lordships, the authorities that say there's no substantive difference between that and the Limb B test we're concerned about. And we can see the facts at page 921, paragraph 3. And the contractual relationship was never the subject of a written agreement. So this is in a context where there's no written agreement at all. And in my submission, that's the first of a number of ways in which our case is a fortiori this case. We cannot be in a worse position because there's a detailed contract here that says this is the type of relationship than the minicab company in a situation where there's no written contract at all. And then Lord Justice Morris Case says it was a type of arrangement which is commonly found in the private hire industry. Mr. Mingley owned a vehicle. He was required to obtain the relevant license from Leeds City Council, showing the name of Amber Cars as the vehicle operator. He was also required to have a standard driving license and evidence of compulsory third-party insurance. All of that identical to our case. Amber Cars made available to him initially a radio and later a computer system, which, according to the finding of the Employment Tribunal, allocated calls to drivers from Amber Cars customers. Now, that's much more primitive than what Uber does, but it's not different qualitatively. In return, Mr. Mingley was obliged to pay Amber Cars £75 a week. So we see here, there's a fixed weekly rental rather than, in our case, a commission. In my submission, that's another way that our case is a fortiori, because if you have a driver who's obliged to pay a weekly rental of £75, that is arguably a significant commercial pressure in the real world that requires him to work. Because if he doesn't work, he'll make a loss automatically. But in the case of Uber, if drivers choose not to use the app and choose not to drive, they don't owe Uber anything at all. And then other aspects of the arrangements are apparent from the following findings of the tribunal. We can see that he worked the night shift, but it was a matter for him as to whether he actually worked those hours. That's exactly the same in relation to Uber. He could work as much or as little as he wanted. Moving down, we see that their concern was that a sufficient number of their substantial fleet of drivers were available for allocation of calls at a particular time. That's exactly the same as Uber's concern. We see that between G and H, he was not entitled to allow any other person to drive his vehicle. He was required to wear uniform, and the uniform code was enforced. That's another way our case is a fortiori. There's a greater degree of control in this case than in our case. The respondents similarly enforced a scale of charges. So the rate of the fare is set by the minicab company. He was not at liberty to amend them. Again, stricter than Uber's system. The respondents did seek to impose a proper code of conduct on their drivers. If there was a complaint from a member of the public, that was investigated in some form of hearing, and the respondents had power to order a refund. Again, exactly the same as Uber. And on those facts, it's found that there is no employment in the broad sense, employment contract. And the key passage is at paragraph 14, the bottom of page 925. Mr. Mingley had to establish his contract with Amber Cars placed him under an obligation personally to execute any work or labour. As the tribunal found, there was no evidence he was ever under such an obligation. Free to work or not at his own whim or fancy, his obligation was to pay £75 a week. And if he chose to work, then to do so within the requirements of the arrangement. And we say that's exactly the same as in our case. Now then, Lord Justice Buxton made some further comment, and in particular at paragraph 23. it was suggested, this is page 927, it was suggested by Mr. Thacker that that requirement, this is the requirement of personal service, was met in this case because Mr. Mingley had obligations to the passenger, to whom he might be directed by amber cars, to execute work in respect of them. Mr. Thacker illuminatingly described such contracts as collateral contracts. That was a correct way of describing them, not only as a matter of fact, but as a convenient legal expression. That work was indeed collateral to the contract between Mr. Mingley and Amber Cars. It was not work under the contract, such as the statute requires. Simply not a contract of the type that falls under the definition of Section 78. Now, again, this is unquestionably a protective statutory scheme dealing with race discrimination. And the court here asking the right question, is this a contract that falls within the scope of the statute, construing the contract and saying the contract here with Amber Cars is for access to their services, to their computer system, subject to their requirements, which include the uniform, the conduct, the setting of the charges, but it's not a contract to work for them. The contract to work is what Lord Justice Buxton describes as the collateral contract with the passengers. Now, in our submission, that is strikingly similar to our case. I don't have to establish it's or not. Yes, my lord.
There is perhaps one significant difference. The Amber Cars had no interest, as I understand it, in the earnings of the individual driver. In the passage you took us to, you listed various things.
Your lordship's right.
But the key point, it may be, is that the Amber Cars got their fee for the use of their material, and then there was no percentage commission going to them thereafter.
Your lordship's right factually. I've made the point that you can argue that the other way, that the fixed fee places more pressure on the driver to work than the percentage commission does. Because the percentage it may give him an overhead he has to meet. I can appreciate that. But the point is actual working. Actual working gives income to Uber. Yes, but my lord, that of course is going to be the case whenever you have an agent who's paid on a percentage commission. The traditional barrister's clerk, the model's agent, the actor's agent. There are many examples of agents who are paid a commission based on a percentage. It doesn't mean that the barrister is providing services for his clerk, even though the clerk may have a powerful financial interest in the barrister working hard and profitably. So your lordship's right factually, but in my submission, that's not a point that could make a distinction such as to make this incapable of being agency. And my lord, I do stress that that's the test. Not, is this a contract that you could see as a worker agreement or as an agency agreement? That what I have to show is simply that the tribunal erred in concluding that the relationships as expressed by the parties were entirely fictional because they bore no relation with reality. And in my submission, we are a million miles from that.
That's, I think, a different point from the one I was making. I was making the point that there is a clear distinction that that Uber has an interest in the amount of money that its drivers bring in, while the Amber Cars did not.
Yes, my lord, that's true. And in my submission, it's true of many other agents too.
I got that point, thank you.
Yes. It's also true of the agent in secret hotels too, for example. Now, my lords, there are a number of other cases in the minicab field that come to similar conclusions, both in relation to employment status and in relation to VAT. I don't have time to show them to your lordships in detail. Can I give you the references in our case It's paragraphs 32 to 45 in our case, pages 92 to 95. And the cases in particular, Khan and Checkers, which is another employment case, and various tax cases, including the case of Mahmood. And you will see in Mahmood set out the tax guidance where HMRC expressly recognises that minicab drivers may operate as principals through the agency of minicab operators. That's a recognised industry model, acknowledged by HMRC. And what you see typically in these cases, that cash work is generally treated as work where the minicab driver is contracting as a principal with the passenger through the agency of the operator. And account work may be either through the agency of the operator or services tendered to the operator where the operator is making the supply. That's the first proposition, that this is a standard industry model. It's not outlandish. And it doesn't depend on me establishing that my facts are identical to those in these other cases. The second proposition is that analogous facts have been treated by senior appellate courts as establishing relationships where individuals have been found to be supplying personal services direct to customers through an agent, even where the principal is closely integrated into the business of the agent, is economically dependent on the agent, and where the agent has significant control over the principal. So that those features are not inconsistent with the relationship of agency. And the two cases in particular are Cheng and Quashie. And Cheng is at page 1111. And this is the case of the golf caddy at the Royal Hong Kong Golf Club. And the position was that the caddy was trained by the golf club, and we can see this from the head note at 1111, provided with a uniform and a locker. The golf club exercised disciplinary powers over him and established a system by which he was allocated to individual members to carry their club. And there's a strict rotation system. Players allocated the next caddy in line. At the end of the day, the claimant was paid in cash by the club for each round he'd worked, the club then debiting the member concerned. So the club operates as agent, both in terms of hiring out the caddies to the members and in terms of the payment. The club pays the caddy and then gets the money back from the member. And the issue was whether the caddies were employees of the golf club or whether they were providing services to the members through the agency of the golf club. Now, the point's taken that the issue here is about employment, not about worker status. But in my submission, that's immaterial to the point for which I rely on this case. Because what was found by the Privy Council in this case, in the absence of a written agreement, was that the only reasonable interpretation of these facts was that the caddies were not providing services to the golf club. They were providing services to the members. And that, in my submission, is very striking, and our case is strongly A40 case. And can I just show your lordships the key passages? You can see the facts summarised at 1114. And the finding was made by the tribunal that in reality, this was a relationship of employment. You can see that at 114F, 114F. The relationship, there exists the kind of control to be expected by employer over employee. Uniform giving of instructions, disciplinary power to dismiss or reducing grade. That finding was overturned by the Court of Appeal. Again, as in this case, only jurisdiction to interfere where there's an error of law. And then the conclusion of the Privy Council is at 1117G. And they say that the Labour Tribunal proceeded on the basis there was a contract of employment and considered only the question whether that contract was one of service or for the provision of services in the light of the authority. In so doing, the tribunal undoubtedly considered with care the authorities on the test to be adopted in drawing that distinction. What it did not do, however, was to consider sufficiently or at all the question as to whether the contract, if any, between the club and the claimant was of a different nature, and whether, if there was a contract of employment, whether of service or to provide services, it was with individual golfers rather than with the club. And so proceeding, the tribunal misdirected itself in a way which justified the Court of Appeal setting aside the finding. And then this, if the tribunal had considered the alternative possibilities, it seems their lordships the true and only reasonable conclusion contradicts the determination that the claimant was an employee of the club. And then they say the only reasonable view of the facts is that the arrangements between the club and claimant went no further than a license by the club to permit the claimant to offer himself as a caddy on certain terms dictated by the administrative convenience of the club and its members. That, in my submission, is exactly the nature of the relationship expressly entered into between the drivers and Uber BV in this case. Found here implicitly by the Privy Council in the absence of any written term. And all the requirements which are treated as relevant to control are treated by the Privy Council as only relating to the requirements imposed for its commercial benefit in order to regulate the license. And the finding is that the payment was by the members and that there's no mutual obligation that the club would employ him and he would work for the club in return for a wage. So that's the finding of the majority. Lord Hoffman dissented, and in my submission, the reasons for his dissent are instructive. It's at 1119, and in particular at F. The club argue that despite the various indicia upon which the tribunal relied, the only proper conclusion was that the claimant was merely licensed by the club to apply for hire on the course. I think not only was Mr. Lynn entitled to reject this interpretation, but it's quite unreal. The club explained the fact they paid the claimant by implying an agency on behalf of the members. They explained the fact that even if the member didn't pay his dues, the claimant would have been entitled to claim payment from the club by implying a contract of guarantee. The need for these implications shows the artificiality of the club's construction. Now, in my submission, that's the exact converse of our situation here. There's no need here to imply a relationship under which Uber collects the fares from the passengers as agent and passes them on to the driver, less its commission, because that arrangement is expressly set out in the contract with the drivers and the contract with the passengers. In fact, it is the tribunal and the Court of Appeal here which have sought to imply a completely different relationship from that expressly identified by the parties. The question is, why is that permissible or legitimate? So that's the Cheng case. If you look at the Khan and Checkers case, the decision of Mr. Justice Langstar, you will see that in the final paragraph of that decision, he refers to this case and says that in his view, the relationship with the minicab driver and the minicab operator that he was considering in that case is analogous to that between the caddy and the club in Cheng. So that analogy was drawn by Mr. Justice Langstaff in the case of a minicab driver. Now, the second case on this topic is the case of Quashie and Stringfellows. And that's at page 928. And here, the degree of integration is even greater. This is the case of a lap dancer at Stringfellows. And the question was whether they were employed by Stringfellows or whether, as Stringfellow said, they were simply licensed to attend at the club and perform dances for clients. Now, I don't want to look at this in too much detail because I'm tight for time, but can I just invite you to look at the facts at paragraph 15, page 931, and the obligations set out at paragraphs 16 to 19. And you will see how closely the dancers were integrated into the club, including the fact that they were expressly under an obligation to work. They had to work particular shifts. But nevertheless, the conclusion at paragraph 48, that there's nothing inherently implausible in the finding of the tribunal that the club was obliged to pay nothing. And then at 49, having made that finding, the tribunal, through an analogy, in my view, justifiably, this is Lord Justice Elias, of course, one of the most distinguished employment judges, justifiably between this case and the golf caddy in Cheng. And then at 50, agreeing with Mr. Linden, that is essentially the same position. It's not employment, it's a license. Now, again, yes, this is a case about a contract of employment, but the finding is not that this is a contract for services to the club rather than a contract of employment. The finding is that there's no contract for services being provided to the club at all. The club is simply licensing the dancers to attend and provide their services to the customers. And you can see the stress placed at 51 on the fact that the dancer took the economic risk. The dancers might make a loss. That is exactly the same as in this case, because in this case, the Uber drivers have to pay for the car, their fuel, all of their licenses, their insurance. They are at economic risk. And one of the flaws I'm going to point to is that economic risk seems to have been equated in this case with who bears the risk of fraud. That's one of the more remote economic risks. The real economic risk here is the economic risk that your costs won't cover your income. So that's the Kwashi case. And in my submission, there's no qualitative difference between the relationship here, both as the contract was performed in reality and as it's set out in writing, and the types of relationships described in those cases. And therefore, no basis to say that the reality of this case is not as described in the contract. The third context, the third submission, is that this court's taken a similar approach, specifically in relation to internet intermediaries. Because, of course, there are two principal analogies that Uber can draw in relation to its business. First is in relation to minicab operators, and the second is in relation to other internet intermediaries, because Uber is both a minicab operator and an internet intermediary. And in relation to internet intermediaries, there is frequently a situation where the intermediary is placing together two sides of a transaction. It might be in relation to accommodation, as in the case of Airbnb. It might be in relation to delivery of food. It might be all kinds of different services that we're now accustomed to get over the internet. Very often, you have individual people being put in touch with individual customers through an agent. And what the Secret Hotels 2 case shows, that frequently in that situation, the agent will be very powerful because the agent controls the platform, and the agent has the brand, and the agent has access to the database of customers. And in that situation, the agent may impose significant obligations on the principal who wishes to use their platform, and they may include onerous obligations. But there is nothing in that that prevents it from being a contract of agency. Now that is that case is in the bundle starting at tab 25. It's page 969. And you see the issue at paragraphs 10 and 12. The issue is, for tax purposes, for VAT purposes, whether the internet platform selling hotel space is contracting as principal, supplying the hotel space, or as agent for the hotels. And it had been found by the Court of Appeal that it was contracting as principal, essentially because of the reality of the relationship, which was held to be inconsistent with agency. It's right to stress that there's no finding here that the contract is a sham. Rather, it's based on the broader principle that my Lord Reed was putting to me this morning. And that is rejected by Lord Neuberger, who says that there is nothing in the way that this contract is operated that's inconsistent with agency. And can I just refer you to the relevant paragraphs? The first tier tribunal found the contract was not consistent with agency. That's paragraphs 14 to 15. Decision of the Court of Appeals summarised paragraph 18. The legal analysis starts at page 981, paragraph 31. Paragraph 32, there is the point that the way that the parties label or categorise their relationship is not determinative. Paragraph 33, the fact that subsequent statements aren't relevant to the construction of the contract. Paragraph 34, there's no allegation of sham, but you're still asking, is this relationship consistent with agency? And we see the HMRC arguments at paragraph 39. And you can see there is an obvious echo of some of the arguments in this case, particularly at the end of paragraph 39, that the agreement was very one-sided. Many obligations imposed on the hotelier. And at 40, Lord Neuberger says, I'm unimpressed with these points. They all stem from and reflect the fact that Med had a substantial business based on the website. This in turn means it had built up a substantial goodwill in the holiday making market, which it wished to protect. It was in a much more powerful negotiating position than the hoteliers with which it was contracting. In other words, an inequality of bargaining power may explain why a contract is advantageous to one party and onerous to another. Doesn't necessarily follow that the contract doesn't reflect reality. And then he makes particular findings about aspects of this contract that are consistent with agency. He makes the point the agent can fix their own commission. He deals with the issues of obligations to compensate. Then if we go over the page to 985, we see questions of whether it makes a difference that Med dealt with matters of complaint and compensation in its own name without reference to the hotelier, didn't provide the hoteliers with invoices, treated deposits and other monies received from customers and their agents as its own monies. Now, again, our case, a fortiori this case, the way that Med was behaving here is far more extreme than the way that Uber behaved. And my Lord Hodge put to me the point about the fixed payment, the £75 versus the commission. But if you look at the commission arrangements here, they give Med far more power and far more of an economic stake in the sale of the hotels than Uber has. Nevertheless, found to be agency. And all of those points are dealt with and rebutted at paragraph 46. The conclusion of Lord Neuberger is at paragraph 50. Lord Justice Underhill's comment on this case, we respectfully adopt. Again, I don't have time to turn on. Can I give you the reference? It's at page 298, paragraphs 153 to 4. So our submission in conclusion is that on a proper analysis, there is no inconsistency between the written terms and the reality of the relationships here, and no inconsistency between those relationships as they were actually operated and the relationship of agency described in the contract, and the direct contract between driver and passenger. So there is simply no reason to treat the written agreements in this case as fictional or to disregard them, whatever approach you take to autoclaim. That brings me to my next topic, which is the errors made by the Employment Tribunal. And if we can turn up the core bundle, we start at page 390. And the court will bear in mind that the principal question here is errors made by the Employment Tribunal, bearing in mind the Jaffrey case, which I showed you, Lordships and Your Ladyship, earlier today. And we start at paragraph 85 at page 390. And then we have the tribunal's finding at 86. When the app is switched on, the legal analysis is, we think, different. We've reached the conclusion that any driver who A, has the app switched on, B, is within the territory in which he's authorised to work, and C, is able and willing to accept assignment, is, for so long as those conditions are satisfied, working for Uber under a worker contract and a contract within each of the extended definitions. Our reasons merge and will overlap in places, but we'll endeavour to keep the main strands separate. Now, before we come on to the reasons, your lordships will immediately see an oddity about that finding, because one of the three conditions that the tribunal is identifying as having to be satisfied in this case in order for the drivers to be within limb B is that they're able and willing to work. In other words, they're volunteering to work. And yet, one of the key requirements under limb B that is in issue in this case is whether the drivers have undertaken to provide work or services for Uber, not whether they're willing to do so. So we submit there's immediately a serious problem in this analysis. We then come on to the meat of the tribunal's reasons. Now, our criticisms of this judgment are extensive and are set out in detail in our case, and we also adopt the criticisms of them that are made by Lord Justice Underhill in their entirety. I want to focus here on the key passages, key paragraphs. If we come to paragraph 90 at this is at page 392, they say, it seems to us that the respondent's general case and the written terms on which they rely do not correspond with the practical reality. So that's the key finding. The notion that Uber in London is a mosaic of 30,000 small businesses linked by a common platform is to our minds faintly ridiculous. In each case, the business consists of a man with a car seeking to make a living by driving it. Now, in our submission, it is baffling as to why that strikes the tribunal as faintly ridiculous. That is the business model of every minicab operator that uses the agency model. Why does it make a difference if it's a mosaic of 150 or 1,000 drivers or 30,000 drivers? In every case, in every minicab company, the business consists of a man with a car or a woman with a car seeking to make a living by driving it. There's then a point about the difficulty of drivers growing their business. That applies to minicab drivers too. Uber's function can't sensibly be characterised as supplying drivers with leads. That suggests the driver is put into contact with a possible passenger to whom he has the opportunity to negotiate and strike a bargain. But drivers do not and cannot negotiate with passengers. They're offered and accept trips strictly on Uber's terms. Again, that applies in every minicab case. Also applied in the Cheng and Quashie cases that we have looked at. So none of the reasons given at 90 for saying that the terms don't correspond with reality stand up to even cursory analysis. And the position gets even worse at 91. This, in my submission, is the central paragraph in the tribunal's reasoning, and it is unsustainable. The tribunal says the logic of Uber's case becomes all the more difficult as it's developed. Since it's essential to that case that there's no contract for the provision of transportation services between driver and any Uber entity, The partner terms and new terms require the driver to agree that a contract for such services exists between him and the passenger. The rider terms contain a corresponding provision. Uber's case is that the driver enters into a binding agreement with a person whose identity he does not know and will never know, and who does not know and will never know his identity, to undertake a journey to a destination not told to him till the journey begins, by a route prescribed by a stranger to the contract, from which he's not free to depart, at least without risk, for a fee set by the stranger, not known by the passenger, who's only told the total to be paid, and calculated by the stranger as a percentage of the total sum, and paid to the stranger. Now, that description, in highly pejorative terms, of the direct contract between driver and passenger is not outlandish at all on analysis. Why does the driver need to know the identity of the passenger and vice versa? Uber knows both of their identities because they're both registered. Uber is acting as the agent. What's the problem? Why does the driver have to be negotiating the fee? Everybody has agreed to contract on the basis of the fee set by the algorithm. So far as the destination is concerned, as we've seen expressly in the written terms, the driver agrees that they will drive on the basis that they're told the destination at the point of pickup. In my submission, the two flaws that underlie this here is that the tribunal reacts with incredulity to a contract, the principal features of which is completely normal in this industry and completely normal in a range of agency relationships of the type we've looked at. Tribunal then goes on. Uber's case has to be that if the organisation became insolvent, the drivers would have enforceable rights directly against the passenger. That, with respect, is nonsense, and the Court of Appeal at paragraph 93 of its judgment recognised the difficulty. Because, of course, the passengers have registered their debit cards or their credit cards with Uber, so they've already paid. If Uber becomes insolvent, so doesn't hand the money over to the passengers, claim will be against Uber. Contracts, if the contracts were worker contracts, the passengers would be exposed to potential liability as the driver's employer under numerous enactments, such as the National Minimum Wage Act. Again, that's a ridiculous statement, as the Court of Appeal itself recognised at paragraph 93, because the driver is contracting with the passenger as a customer, as in the case of every minicab driver who operates a similar arrangement. And then the tribunal says this: the absurdity of these propositions speaks for itself. So the basis of the tribunal's finding that these written terms don't reflect reality is that it regards what is a perfectly normal and orthodox type of contract as absurd, and does so partly on the basis of a failure to understand the features of such an ordinary contract, and partly on the basis of at least two legal misconceptions in relation to insolvency and the applicability of the NMWA. Not surprisingly, they go on, it was not suggested that in practice drivers and passengers agree terms. Of course they do not, since apart from any other reason, by the time any driver meets his passenger, the deal has already been struck between ULL and the passenger. Again, that's not very surprising if ULL is acting as agent. You'll note the constant reference to Uber as a stranger to the contract, which again is an odd characterization. And then they say it's necessarily part of Uber's case that where through fraud or for any other reason a fare is not paid, it has no obligation to indemnify the driver for the resulting loss. Accordingly, insofar as the policy is to bear the loss and protect the driver, it must be free to reverse the policy. If it does so, drivers will be left without remedy. That would be manifestly unconscionable. That's another finding that the Court of Appeal, we so rightly deprecated. And then finally, they say, for all these reasons, we're satisfied that the supposed driver-passenger contract is a pure fiction, which bears no relation to the real dealings and relationships between parties. Now, in my submission, the basic question for this court is whether that reasoning is flawed. And if it is flawed, in my submission, whatever your lordship's and your ladyship's view is and the proper scope of auto-claims, this appeal needs to be allowed. And either the decision needs to be reversed, or if the court remains in any doubt as to the correct answer, the matter needs to be remitted for a rehearing. But in my submission, that reasoning simply cannot withstand the materials that we've looked at, including the case law we've looked at. This is not an absurd contract that flies in the face of reality. Then at 92, they state that they agree with Mr. Linden, it's not real to regard Uber as working for the drivers. The only sensible interpretation is that the relationship's the other way around. Again, in my submission, that's a very strange way of putting it, which misses the point. The question is not, is Uber working for the drivers or the drivers working for Uber? The question is, are the drivers providing services to Uber, or are they providing services to the passengers through the agency of Uber? The different question. And if they had addressed the agency question correctly, they would have concluded that each of the points that they make here, paragraph 13, is not inconsistent with agency. Each of the points that you see set out at 92, 1 to 13, is a feature of the cases we've been looking at, which has not been held to preclude an agency relationship. But because the tribunal here asks itself the wrong question, it concludes that integration and control are fatal to Uber's case. Not so. Now, we have some specific criticisms of some of these paragraphs. We say that in a number of them, the tribunal is simply relying on features that are part of the regulatory obligations of ULL. And those include, in particular, you'll see, by the way, we've dealt with this in our written case in detail at paragraphs 93 to 94, it's pages 113 to 4. At subparagraphs 1, 2, 3 are all regulatory requirements. Now, subparagraph 4, we have challenged as a perverse finding of fact. What the tribunal says is the fact that Uber requires drivers to accept trips and or not to cancel trips, and enforces the requirement by logging off drivers who breach those requirements. You've seen my submissions, both on what the contracts actually require and what the policy says. And in our submission, that they don't and are not capable of supporting that finding. You have my submissions on most of these other findings. We say most of them are entirely neutral. Then at 93, they say that for the reasons already stated, we are clear that they provide their work for Uber. So that's the finding that they make without ever addressing the question properly of the agency. And it's based on their conclusion that there's no direct contract with the passengers for the reasons given at 91. And they say, later in the same paragraph, they say, we're entirely satisfied the drivers are recruited and retained by Uber to enable it to operate its transportation business. The essential bargain between driver and organisation is that for reward, the driver makes himself available to and does carry Uber passengers to their destinations. That's the contract that the tribunal has implied between these drivers and ULL. It's wholly incompatible with the terms of the written agreement and with the written agreement that the passengers have with Uber. But the tribunal has failed to justify the implication of such a radical departure from the parties' terms. And they then rely on auto-cleanse because they say it bears no relation to reality. And that takes you back again for the reasoning at 90 to 92. They then, at 94, rely on the authorities, and they're talking there particularly about Cotswold developments and red caps. And you have my submission that those authorities were addressing a different question about whether or not the relationship was a relationship of client or customer. They're not addressing the question who the services are being provided to. The cases that address that question are Mingley, Hoshi, and Cheng. Now, the tribunal then comes on to deal with those cases at 95 and essentially says they're all irrelevant. And they say none of the authorities turned on the Limb B test. You already have my submission about why that misses the point. And it says they're largely concerned with whether there's an umbrella contract. And then they say the facts are different. This is at 3. And they suggest that Cheng and Quashie can be explained on the basis that in those cases, the employees were providing services that were ancillary to the main function of the employer. Now, it's a surprise to me that lap dancing is ancillary to some other function of Stringfellow. But be that as it may, it is impossible to understand what the relevance of that factual point is. Mingley and Khan, they deal at subparagraph 4. They concede that the facts are closer to those of the incident case, and they just say there was ample room in both for the finding that the arrangements between the parties were consistent with the claimant personally entering into a contract with each service user. As we've explained, there's no room for that interpretation to be placed on the dealings between the Uber driver and his passenger. That finding reached without acknowledging the fact that all of the supposedly absurd features of the contract that they've identified at 91 apply in those cases too. And then at 96, they repeat that the terms don't correspond with the reality of the relationship, and therefore they say the tribunal is free to disregard the contract. And that essentially outlines what we say are the basic flaws in this decision. Can I then turn to the Court of Appeal's judgment, which did identify some of these flaws, but nevertheless decided that it could go on to conclude that the decision was right anyway, and introduced in our submission some further flaws of its own. And that starts at page 239. I've already indicated to your lordships that we submit that Lord Justice Underhill got it right and we adopt his judgment. And I want to focus on the judgment of the majority, the Master of the Royal Son of Justice Bean. And first of all, we submit that there is an error in the way that this court interpreted auto-cleanse. And you see it, first of all, at paragraph 73. They say, auto-cleanse shows that in the context of alleged employment, taking into account the relative bargaining power of the parties, the written documentation may not reflect the reality of the relationship. That we don't disagree with. Then they say the parties' actual agreement must be determined by examining all the circumstances of which the written agreement is only a part. This is particularly so where the issue is the insertion of clauses subsequently relied on by the inserting party to avoid statutory protection which would otherwise apply. In deciding whether someone comes within either limb of section 233 of the ERA, the fact that he or she signed a document will be relevant evidence, but not conclusive whether terms are standard and non-negotiable, and whether parties are in an equal bargaining position. Tribunal should take a realistic and worldly wise position. Now, most of that's unobjectionable, except the suggestion, first of all, that the written agreement's just a part of the circumstances, and secondly, that the court's ability to find that the terms are different from those expressly agreed is enhanced if the effect of those terms will determine whether somebody does or does not come within limby. The way that a contract is construed cannot depend on what are the outcomes of the different constructions in terms of fiscal or legislative protection. Contract must be construed on normal principle. But as I've said, I entirely accept that the written terms are not conclusive. The question is whether there is really any inconsistency between those terms and reality. Now, the court returns to the issue again at paragraph 106. Sorry, 105. It's page 281. And they say that one of the main reasons for their disagreement with Lord Justice Underhill is the extent to which AutoCleanse permits the court to ignore written contractual terms which don't reflect what reasonable people would consider to be the reality. The latter concerns the question as to what reasonable people would consider to be the reality of the actual working relationship. Now, in my submission, that phrase, what reasonable people would consider to be the reality, is somewhat too broad. The question is the question that was posed in AutoCleanse itself, which is what is the actual agreement between the parties, not what's reasonable. And then they say that the extended meaning of sham in AutoCleanse provides the common law with ample flexibility to address the convoluted, complex and artificial contractual arrangement, no doubt formulated by a battery of lawyers, unilaterally drawn up and dictated by Uber to tens of thousands of drivers and passengers, not one of whom is in a position to correct or otherwise resist the contractual language. As to the reality, not only do we see no reason to disagree with factual conclusions, we consider the tribunal was plainly correct. So they've made their own finding that the decision was correct. Now, coming to the Court of Appeal's actual analysis, we go back to paragraph 74, page 273. And there is, on analysis, really only one reason why the Court of Appeal concluded that the reality here was inconsistent with the written agreement. And it's the reason that you see at paragraph 76. In that paragraph, what the Court of Appeal says is acceptance of the request by the driver means subject to the right of the driver and passenger to cancel, in parenthesis, rather unimportant right. The driver is expected to proceed to collect the passenger from the notified location and complete the journey. That's consistent with the language of 2.4 of the new terms, which talks of the option to cancel an accepted request. In the language of AutoCleanse, the reality is that at that stage, there's an obligation on the driver to fulfill that expectation. The contractual documentation states that at that stage, there's a contract between the driver and the passenger, but that cannot be correct as vital elements of any such contract are missing. Now, although they say vital elements, there's only one vital element, and it's in the next sentence. The driver does not know at that point a fundamental fact, namely the passenger's destination, because he only gets that information at pickup. This is the only reason why the Court of Appeal has held that the reality doesn't reflect the contract. That at the point where the driver accepts the request, he doesn't know the destination. Now, in my submission, that's unsustainable. There is no reason whatsoever. Sorry, beg your pardon.
I'm sorry to interrupt my friend mid-flow, but I'm conscious of the time. It's 3:30. And in the estimates that we submitted to your lordship, she ought to have wound up her submissions by now. She hasn't got on to what counts as working time. If she needs to continue and you're willing to let her, so be it. But there might need to be a corresponding adjustment made to her reply, my lords and lady.
Yes. Ms. Rose is very familiar with the way this court operates, and we're not losing sight of the clock. If she goes beyond past, then it comes off her reply time.
Well, my lords, just to return to this point, in our submission, it's unsustainable as a matter of legal principle to say that there can't be a contract between the driver and the passenger, because at the time that the driver accepts the request, he doesn't know the passenger's destination. There's no reason why the driver can't contract to drive the passenger to their destination in accordance with the standard terms of the app, including the standard fee in the app. Now, there's a particular oddity about this, because if you look at paragraph 80 on page 274, the Court of Appeal finds that the contract at the point of acceptance of the request must be with ULL. In other words, the passenger is contracting with ULL. But as we've seen, the passenger may not tell ULL the destination. So the Court of Appeal is finding that the fact that the driver doesn't know the destination precludes a contract between driver and passenger, but does not preclude a contract between ULL and passenger. This is an impossible finding. And it's the only basis on which this court found that the contract didn't reflect reality. As you can see from paragraph 78, in their draft judgment, they came up with another, even with respect, stranger suggestion that there was no consideration. It's a completely new point and an obviously bad point. And after we made submissions, the Court of Appeal withdrew that point, but still maintained the rest of the structure of this section. So it rested then on only this single point. And you can see at 93 that the Court of Appeal expressly rejects a large chunk of the tribunal's reasoning of paragraph 91, but says, oh, well, it's not terribly important, it's not essential to its conclusion. But essentially what the Court of Appeal has done is strip out everything from paragraph 91 of the original ET decision, rely only on what we say is this bad point about destination, and rest its whole decision on that. Now, they then go on to consider other factors. Uber's public statements. We've dealt with these in our written case, and Lord Justice Underhill deals with them too. I would flag, most of these we say are simply neutral and irrelevant. Particularly odd is the reliance on a statement made by an employee of ULL to the fact that drivers are paid a commission of 80% for every journey they undertake. There's no finding that that's actually the position. Why would a statement made unilaterally by an employee of ULL, who's not even involved in the payment mechanism, that's UBV, be held to contradict the express terms of the contract for payment between passenger and UBV and driver and UBV, and the way that the contracts are actually implemented? It's a bizarre proposition. They then go on to the ET's finding that the drivers are working for Uber. This is effectively paragraph 92. And they make the same error that the tribunal does here, not appreciating that all of these points about integration are applicable to agency arrangement. In relation to regulation, this is paragraph 87, they entirely misconstrue our submission. They say at 87 that our submissions repeatedly referred to the regulatory regime as if it were irrelevant or trivial important. They did no such thing. The submission we make to the Court of Appeal is the same as the submission I've made to this court, which is that the regulatory regime is very important, but it can't support a finding of worker status because it's got nothing to do with contractual negotiation or agreement. It's imposed on the parties, and it's imposed in an industry where both models are recognized. So for those reasons, and the other reasons that are set out in detail in our written case, we submit that both the Employment Tribunal decision and the Court of Appeal decision that these contracts don't reflect reality collapse on analysis. There's no inconsistency between these contracts and reality. My Lords, very quickly, can I just deal with issue 2? Can I pick it up from our written case? That's in the core volume at page 127. We deal with this from paragraph 130. Now, in summary, in summary, both for the purposes of the working time regulations and the National Minimum Wage Act, the question is, over what period are the drivers working? And the finding of the tribunal, as we've seen, is that they're working whenever they're in the territory with the app switched on, able and willing to work. And we submit that that is not correct. If we're wrong on issue 1, the only times that they're working are when they are actually driving the trip. It is wrong to regard the drivers as either working or at Uber's disposal when the app is on. First of all, the condition that they must be able and willing to work is a bootstraps argument to say they're at their disposal if they're willing to be at their disposal. Makes it clear that they're not obliged to be at their disposal. Secondly, we've seen that the drivers are entitled simultaneously to have 2 apps switched on, or 3 or 4. Let's take a driver who goes out at 4 o'clock in the morning and there doesn't have to be any work around. And they switch on the Uber app and they switch on another similar driving app. And for an hour, they drive around and there is no work. On the Employment Tribunal's analysis, they're entitled to claim the minimum wage from both of the owners of those 2 apps on the basis that they were able and willing to work, even though they had both switched on at once. That's a very startling conclusion. My Lords, I apologise for going slightly over. I think I've gone 9 minutes over. Unless there are any further questions, those are my submissions for the appellant.
Thank you very much, Ms. Rose. Mr. Galbraith-Martin.
My Lord, my Lady, thank you. I'll just begin by quickly outlining the structure of our submissions. Mr. Siegel and I have had discussions and we've divided up the time that's available to us, and we will hopefully avoid any unnecessary duplication in our submissions. For the remainder of this afternoon, I'm going to say something about what we say is the highly relevant backdrop against which the issues in this case need to be decided. That's the employment protection regime and also the private hire regulatory regime. And then I'll also look at what we say is the correct approach to be adopted in this case. I'm going to cover the relevance of EU law and also look at the reversal of the burden of proof in section 28 of the National Minimum Wage Act. And then I'll turn to what we say is the central issue in this case. And having heard Ms. Rose, I really do think it is the central issue. There doesn't appear to be that much between us on the law. Whether the Employment Tribunal was entitled to find that drivers work for Uber. And I'm going to highlight what we say are 2 critical inconsistencies between the written agreements on which Uber relies and what the Employment Tribunal in this case found to be the true agreement between Uber London and its drivers. Unlike Ms. Rose, we say, and I'll take you to it, the Tribunal did find that the reality was inconsistent with the written terms. Time permitting, I'll also address quickly the relevance of the regulatory regime and whether the Employment Tribunal was right to identify rights and obligations in the contractual arrangements between the relevant parties, notwithstanding the fact that they might also be a requirement of the regulatory regime. And I should be sitting down, so to speak, around about 12:30 tomorrow, now that Ms. Rose has gone on a little further. Mr. Siegel will specifically deal with the question of what counts as working time. So the challenge to the second finding that was made by the Employment Tribunal. So that's an overview of what Mr. Siegel and I are going to cover. But by way of introductory remarks, I'd like to set out 5 short, simple propositions which essentially summarise why we say, and taking the complete opposite approach to Ms. Rose, whatever view you take about the proper approach to be adopted and her arguments about autoclaims, whatever view you take about those arguments, this appeal should be dismissed. First, so whatever approach the court or tribunal should adopt when the relevant parties have entered into a contract which purports to determine their relationship, in this case, as my Lord Legate has highlighted, there is no written contract between Uber London and its drivers. I was somewhat taken aback when, in answer to a question from my Lord Legate and then my lady, Miss Rose said, for what I think is the first time in either the EAT, the Court of Appeal, or as far as I'm aware, the Employment Tribunal, that if one is looking for an express appointment of Uber London to act as the driver's agent, one need look no further than what happens at the point of recruitment. That has never been part of Uber's case. It has never been suggested that when drivers attend to take part in what the tribunal found was an interview for a job, anything said or done at that meeting constitutes the appointment of Uber London as the driver's agent. And there is not one piece of documentary evidence in support of the proposition that she put to you. In fact, if you look at the notice of appeal, you'll see a very different point is made about what is said to constitute the source of the agency. It's at page 33 in the electronic bundle, the electronic page 33. This is paragraph 56, please, about halfway down, about a third of the way down that page. So paragraph 56(2). And about 5 lines up from the bottom, you'll see it says, drivers consent to Uber London having authority in that regard, both by entering into the partner terms with UBV and by their subsequent conduct. Never any suggestion that there's an express appointment when they attend or interview. In our submission, Ms. Rose's response to my Lord and my Lady's question is plainly just an afterthought to meet what's an obvious lacuna in Uber's case here. The lack of any document properly spelling out a relationship of agency as between Uber London and drivers. And the Court of Appeal was entitled to and right to comment on that. So the first submission, whatever approach you take, when the parties have entered into a written agreement, when they haven't, the approach to be adopted is that set out in the Carmichael case, and I'll take you in due course to what Lord Irvine and Lord Hoffman had to say in that case. The written documents relied upon by Uber constituted one, albeit important, source of material from which the tribunal was entitled to infer the true agreement between the relevant parties. So for this case, that's the correct approach. Second, as Lord Hoffman made absolutely clear in the Carmichael case, and the Court of Appeal unanimously agreed in our case, it follows that the determination of the true relationship between Uber London and its drivers was a question of fact for the Employment Tribunal, requiring it to make an evaluative judgment based on all relevant evidence. We accept that that includes the written agreements, but it legitimately also includes things that would not be admissible to construe a purely written contract, such as the subsequent conduct of the parties, or evidence as to what they understood their respective obligations to be. And as paragraph 56(2) of the Notice of Appeal makes clear, Uber relying on the subsequent conduct of the parties, they say in order to evidence an agency relationship, we must be ad idem up to this point. So this is not about the construction of a written document, rather it is about the identification of true agreement between the parties where there is no written document which constitutes their agreement. Third, taking that approach, the Employment Tribunal in our case determined as a fact that the claimants work for Uber. Their finding is neatly encapsulated in a sentence that Miss Rose took you to towards the end of her submissions. It's paragraph 93 of the Employment Tribunal's judgment. I don't need to take you back to it. But this is the finding. The essential bargain between driver and organisation is that, for reward, the driver makes himself available to and does carry Uber passengers to their destinations. That's the critical finding made by the tribunal in this case. And Ms. Rose, at the very end of her submission, said, that's wholly incompatible with the written documents. We agree. It's why the Employment Tribunal in this case was entitled to disregard the written documents, because it found the true bargain with the parties, between the parties, was incompatible. Fourth, in making that determination, the tribunal made findings of fact about the relationship between Uber London and its drivers, which are wholly inconsistent with the written terms on which Uber relies. I'm going to take you back to these in more detail as I develop my submissions. But contrary to the express provisions in clause 2.4 of the new terms, the tribunal found that Uber does impose numerous conditions on drivers. It instructs drivers as to how to do their work and in numerous ways controls them in the performance of their duties. Paragraph 92.7 of the decision. Again, I don't need to take you to it at the moment. The tribunal also found, contrary to the written terms on which Uber relies, drivers are, whilst on duty, contractually bound to accept, at the very least, a reasonable number of trip requests. They're not obliged to accept them all, but in our submission, that doesn't matter. They're obliged to do at least some work. Now, those two findings, of course, have to be taken together with facts not in dispute in this case, that the drivers are required to perform their work personally, and that Uber is not a client or customer of any business carried on by its drivers. Fifth, as Lady Hale said, and we agree, in the Bates case, there can be no substitute for applying the words of the statute to the facts of the individual case. And with respect, my Lord Reid, I think this is the point that you were making earlier to Miss Rose. On the facts found by the tribunal, read together with those not in dispute, the finding that the claimants are workers for the purposes of the relevant statutory provisions was, we submit, not only right, it was inevitable. The claimants undertook, pursuant to the bargain identified by the tribunal, personally to do work for Uber, who was not a client or a business of an undertaking carried on by them. And if you accept those propositions, you must dismiss the appeal, whatever view you take about the arguments on the proper approach. In our submission, the real importance of this court's judgment, and it's being keenly watched by those in the employment community, is for those cases like AutoCleanse, in which the relevant parties have entered into a written agreement which purports to define their relationship. Perhaps too for people like Uber drivers, if, and Miss Rose enticingly dangled this in front of you, but without giving you any detail, Uber responds to your Lordship's judgment and my Lady's judgment simply by issuing new terms, perhaps requiring its drivers to enter into a written agreement by which it expressly purports to appoint Uber London as its agent. The real issue in those circumstances will be whether a court or tribunal is entitled to go behind the terms of that agreement, but we stress that's not this case. But even understood in that broader sense, and we are inviting this court to say something about that situation, in our submission, this litigation is an attempt by Uber to have its cake and to eat it too. It wants to distance itself from its drivers when it comes to statutory employment rights and protections, but for understandable commercial reasons, this is, after all, a multi-billion-dollar company. it wants to exercise a considerable degree of control over the minicab service that it plainly offers. The Employment Tribunal found it can't have it both ways. With that short introduction, can I now turn to what we say is the critical statutory backdrop to this case? As Her Honour Judge Eadie observed when giving her judgment in the Employment Appeal Tribunal, the Employment Tribunal was required to determine the relationship between Uber London and its drivers for the purposes of statutory provisions in the field of employment law. Those are provisions enacted specifically to provide protection to those all too often disadvantaged by the common law doctrine of freedom of contract. The rationale for this was set out very clearly by Lord Hoffman in the seminal case of Johnson and Unisys, and I'd like to take the court to that very briefly. It's in the electronic bundle, 876. My lords and my lady might know that this case is very different factually from our own. I'm not proposing to say anything about the facts of that case unless you require me to, but what is said here by Lord Hoffman is plainly of general application to the statutory employment protection regime. So at paragraph 35 at the top of the page, reading about 4 lines in, at common law, the contract of employment was regarded by the courts as a contract like any other. The parties were free to negotiate whatever terms they liked. No terms would be implied unless they satisfied the strict test of necessity applied to commercial contract. Freedom of contract meant that the stronger party, usually the employer, was free to impose his terms upon the weaker. But over the last 30 years or so, the nature of the contract of employment has been transformed. It has been recognised that a person's employment is usually one of the most important things in his or her life. It gives not only a livelihood, but an occupation, an identity, and a sense of self-esteem. The law has changed to recognise this social reality. Most of the changes have been made by Parliament. The Employment Rights Act consolidates numerous statutes which have conferred rights upon employees. European Community law has made a substantial contribution. But of course, we're going to take you to and rely on European Community law.
But the last sentence there of the paragraph is also perhaps one that needs to be borne in mind in looking at some of the older authorities.
Indeed. My lord, that's absolutely right. There's the reference in that last sentence, which then Lord Hoffman goes on actually to explore in the paragraph that follows the contribution of the common law, but not particularly relevant for our purposes. But my lord's quite right to draw that to my attention. And I'm going to take you next to what my lord, Lord Reid, had to say in the more recent challenge to the ET fees and that we set out in our written case. Can I take you to 1814, please, 1814? So that was said as long ago by Lord Hoffman, as long ago as 2003, but said again by my lord, Lord Reid, much more recently in the ET fees challenge case. 1814, in the interest of time, taking the court to the relevant passages rather than the start of the case. I hope that's acceptable. But paragraph 6, relationships between employers and employees are generally characterized by an imbalance of economic power, recognizing the vulnerability of employees to exploitation, discrimination, and other undesirable practices and the social problems which can result. Parliament has long intervened in those relationships so as to confer statutory rights on employees, rather than leaving their rights to be determined by freedom of contract. In more recent times, further measures have also been adopted under legislation giving effect to EU law. In order for the rights conferred on employees to be effective and to achieve the social benefits which Parliament intended, they must be enforceable in practice. Now, in that paragraph, my lord is referring specifically to the position of employees. That's those employed in the traditional sense under a contract of employment, but there's no doubt that the same social policy objective applies in the case of workers. Workers, of course, are very likely to be self-employed for tax purposes, and to some extent, therefore, in business on their own account. it's no answer to a case such as the present to say, well, Uber drivers are self-employed. They get the benefits of being self-employed. That may be true, but they can still fulfill the statutory criteria and show that they are workers. The broad distinction between the sort of self-employed people who do qualify for statutory rights and those that don't was addressed by Lady Hale in the Bates case. Very briefly, my learned friend didn't take you to these paragraphs, so if I can, page 801, please. And at paragraphs 24 to 25, so first, the natural and ordinary meaning of employed by is employed under a contract of service. Our law draws a clear distinction between those who are so employed and those who are self-employed but enter into contracts to perform work or services for others. Second, within the latter class, the law now draws a distinction between two different kinds of self-employed people. One kind who carry on a business or a business undertaking on their own account and enter into contracts with clients or customers to provide work or services for them. The other kind is self-employed people who provide their services as part of a professional business undertaking carried on by someone else. So one can be self-employed, but nonetheless be a worker for the purposes of the relevant statutory provisions. Lord Justice Underhill, in fact, Mr. Justice Underhill, as he then was, had a little more to say about this in the case of Byrne Brothers, which you've seen referred to in some of the other cases. It's actually referred to at length by the Employment Tribunal in this case, and I'd like to take you to their citation of it, because I'd like you to see that the Employment Tribunal were aware of what Mr. Justice Underhill had to say in the Byrne Brothers case about workers. So this, please, is at page 383. So this is reading from the decision of the Employment Tribunal at paragraph 75, and you'll see in Byrne Brothers, Mr. Recorder Underhill, I'm sorry, I promoted him to Mr. Justice at that time, Mr. Recorder as he then was, Underhill, in the Byrne Brothers case, sitting in EAT, offered this guidance on the proper interpretation of the definition of the LIMB worker, and then picking it up at subparagraph 2. Carrying on a business undertaking is plainly capable of having a very wide meaning. In one sense, every self-employed person carries on a business, but the term cannot be intended to have so wide a meaning here, because if it did, the exception would wholly swallow up the substantive provision, and limb B would be no wider than limb A. And then down to 4, please, on the same page, it seems to us that the best guidance is to be found by considering the policy behind the inclusion of limb B. That can only have been to extend the benefits of protection to workers who are in the same need of that type of protection as employees stricto sensu, workers, that is, who are viewed as liable, whatever their formal employment status, to be required to work excessive hours or to suffer unlawful deductions from their earnings or to be paid too little. The reason why employees are thought to need such protection is that they are in a subordinate and dependent position vis-à-vis their employers. The purpose of the regulations is to extend protection to workers who are substantively and economically in the same position. Thus, the essence of the intended distinction must be between, on the one hand, workers whose degree of dependence is essentially the same as that of employees, and on the other, contractors who have a sufficiently arm's length and independent position to be treated as being able to look after themselves in the relevant respects. Drawing that distinction in any particular case will involve all or most of the same considerations as arise in drawing the distinction between a contract of service and a contract for services, but with the boundary pushed further in the putative worker's favour. And this is important. It may, for example, be relevant to assess the degree of control exercised by the putative employer. Of course, we say that's very relevant here. Other factors include the exclusivity of the engagement, its typical duration, the method of payment, what equipment the putative employer supplies, the level of risk undertaken, etc. It's a multifactorial test. The basic effect of limb B is, so to speak, to lower the pass mark so that cases which failed to reach the mark necessary to qualify for protection as employees might nevertheless do so as workers. My Lords, and I'll just finish on this as I see the time. In our submission, there is absolutely no doubt that we are here concerned with or relating to use the language of Lord Justice Aitkins in the Court of Appeal in Autoclens, a relationship concerning or relating to work or services. I'll make this point good when we recommence tomorrow morning, but my clients did at the material time earn their living from driving a minicab for Uber. It was their job. And all the tribunal has found, in essence, is that they are deserving of that statutory protection referred to by Mr. Recorder Underhill in the Byrne Brothers case. My Lords, it's gone 4 o'clock. My lady, I'm happy to leave it there and to pick it up tomorrow morning.
Can I just ask, are you planning to take us to the Ramsey line of cases in tax law?
Mr. Siegel is proposing to do that. He makes much of that in his written case, my Lord. I can touch upon it if you want me to, but stealing his thunder, I think, if I did.
I was just going to mention that if we are to be taken to those, you might want to look at a case called UBS. It's a Supreme Court case in 2016, which has something to say about how the Ramsey approach affects the analysis of facts. It's a matter for you. I'm just mentioning it in case you find anything in it that you feel you need to draw to our attention.
My Lord, I'll certainly look at that overnight. I do know that Mr. Siegel is proposing to address you in relation to those, but perhaps he and I we'll put our heads together and see whether it's something I can sensibly deal with.
Thank you. Well, thank you very much. We'll adjourn there for the day and resume at 10:30 tomorrow morning.
Thank you.